felonious assault, Ohio Revised Code Section 2903.11A1, and/or endangering children in violation of Ohio Revised Code Section 2919.22B2. Do you have an attorney? You do? Do you have the money or means to hire an attorney? Have you received your indictment?
I don't.
Okay. Have you read it?
No.
You have not read it.
I read
Okay.
it to you back there, right? I did not.
We have a copy here. You can read it.
On June 3, 2024, 34-year-old Bionca Ellis stole 2 knives from the Volunteers of America thrift store located next to the Giant Eagle supermarket in North Olmsted. After leaving the thrift store, Ellis entered the Giant Eagle, where she noticed 3-year-old Julian Wood and his 37-year-old mother shopping. She followed them into the parking lot where she brutally attacked, stabbing the toddler multiple times as he sat in a shopping cart. When Julian's mother tried to rescue her son, she too was stabbed. Police officers from North Olmsted quickly arrived and arrested Ellis, who was still carrying a knife. Both victims were rushed to a nearby hospital, but despite medical efforts, Julian was pronounced dead. His mother was treated for her injuries and survived. In another case, questions continue to swirl around Bionca Ellis and her possible connection to past incidents. Did Ellis kill someone in Bakersfield? Could there be an unsolved murder linked to her? And does she have a pattern of spontaneous violent behavior? While speculation remains, Bakersfield Police Department, BPD, has stated that the case involving Ellis in their jurisdiction is closed. Ellis has a history of minor criminal offenses. She was previously arrested for petty theft at a Walmart in Ohio and for a non-violent crime in Florida. Investigators said that there was nothing in her past suggesting she had violent tendencies. A week before the murder, she was arrested for a theft.
Hello. Are you all right?
Yeah, I'm going over here to the bus stop.
You're okay though? Somebody called because they were concerned about you.
Yeah, I kind of get lightheaded from my medicine.
5221, I'm out. Do you need assistance at all? Or you need an ambulance or anything? Are you feeling all right?
No, I think the temperature is just getting to be just right.
Okay. Do you have an ID on you just so I can tell them that you're all right? Are you from around here or are you trying to get out of here? Both? Thank you. 5221 on 3. Copy. All right, Bionca, you know you got warrants. Girl, I don't know. They're
Probably for here, yeah.
Yeah, so we gotta check on those, all right? You got anything crazy on you? No guns, knives, drugs, bombs? Nothing like that? All right, I'm gonna check. Are you able to stand at all? Okay. Do you have any medical problems going on right now?
No.
You take any drugs, any alcohol?
No.
You pregnant?
So, what do you need me to do? You need me to get
All right, yeah, can you stand up for me? Copy. Is it within pickup? Let me know. All right. You got anything on you at all? We're going to come back to my car, okay? He'll grab your bag in a second. That's fair? Go ahead, face me for a second. Right here. Thank you, ma'am. I don't want to pinch you. Let me lock them so they don't tighten up on you, okay?
After her arrest for the murder, Ellis was held on a $5 million bond, and prosecutors announced their intent to seek the death penalty. And her appearance in court, smiling after committing such a heinous act, caught media attention.
Do you have an attorney? You do? Do you have the money or means to hire an attorney? Have you received your indictment?
I don't.
Okay. Have you read it?
No.
You have not read it.
I read
Okay.
it to you back there, right? I did not.
We have a copy here. You can read it.
I don't want to read it.
You don't want to read it.
No.
Are you willing to accept that the public defender has read it to you?
I asked her not to.
I'm sorry.
I asked her not to.
You asked her not to. Well, but she did read it to you, correct?
No.
She didn't read it to you.
I read it.
Okay, well, we can read it in open court. Count 3 alleges that on or about June 3rd, 2024, the defendant did cause the death of J.W. date of birth 10/29/2020, as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault, Ohio Revised Code Section 2903.11A1, and/or endangering children, in violation of Ohio Revised Code Section 2919.22B2. Count 4 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to J.W. on date of birth 10/29/2020. The defendant did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation. I have now read the indictment to you. Do you wish to enter a plea of not guilty?
C.
Pardon me?
C.
What's saying mean? Yes or no?
Yes.
Okay. I understand the victims are represented and they want to make a comment before I set bond. Is that true?
Yes, Your Honor.
Good morning, sir. Could you start with your name?
My name is Jared Wood, father of the deceased, husband of Margot. Your Honor, that day, 1 week ago, she took everything from us. There's nothing that could ever replace my son, or anything that my wife and I, or even our other kids, are going through. It's horrendous. And I really wish no bail, period, or extend it to the max limit possible that you can, at the very least. Just do whatever you can to keep this monster behind bars.
Thank you, sir. Is there anything else you would like to say?
That'll be it. Thank you, Your Honor.
Thank you. When the original bond was set out of Muni Court, the bond was set at $1 million, and it was before the passing of one of the alleged victims. I do not believe that bond is appropriate given the change in circumstances and the allegations that are contained in this indictment. Bond is set at $5 million, cash, surety, or property. GPS, no contact with any surviving victim or victim's family, DNA order. Judge is John Russo. Pretrial is June 17th at 9 a.m.
Ellis was a patient at Kern Medical when she allegedly attacked 3 hospital staff members. Police say Ellis refused to leave after receiving treatment, and when security attempted to escort her out, she kicked 2 security guards and a nurse. She was arrested and charged with 3 counts of misdemeanor battery, though no court hearings have been scheduled in connection with those charges. Ellis's attorneys entered a plea of not guilty by reason of insanity. The defense called psychologist Dr. West, who claimed that Ellis did not know what she was doing when she attacked little Julian.
It is my opinion with reasonable medical certainty that on June 3rd, 2024, Ms. Ellis was indeed suffering from symptoms associated with schizophrenia, a severe mental illness.
However, prosecutors challenged her claims using video footage showing how she meticulously selected knives with thought process and precision, suggesting her actions were calculated.
So that would be a very thoughtful process. Don't you agree with me?
I think it was a process. It doesn't sound, I don't know what her considerations were.
The state called its own expert, Dr. Knopfsinger, a forensic psychiatrist, to refute the claims of Ellis's mental illnesses.
Did you kill that little boy on purpose? Did you stab him on purpose? Was it an accident?
During sentencing, prosecutor Michael C. O'Malley described the case as one of the most heartbreaking acts of violence he had ever seen. Following a week-and-a-half-long trial, a jury found Ellis guilty on 9 counts, including aggravated murder, felonious assault, child endangering, and aggravated theft. She was sentenced to life in prison without the possibility of parole for killing the 3-year-old boy outside the grocery store. Her lawyers, Fernando Mack and Carlos Johnson, called the verdict the wrong outcome, and confirmed plans to appeal. In a statement, Julian's father, Jared Wood, said,
And thank you. I'll hear from you this morning.
Oh, thank you. I am here today to speak on behalf of my son, Julian Miles Wood, who is no longer here to speak for himself, and I am thankful for you to be giving me this opportunity to do so. It's hard to know where to start when talking about him, so I guess I'll start with letting you know that our family is no stranger to the struggles of cognitive or behavioral differences. Our oldest child has autism. He was actually considered nonverbal, and it wasn't until he was about 7 years old when he became verbal. We tried everything we could to help as parents. But who I should say, actually got him to break free and open up and talk to the point to where we have actually a hard time getting him to stop now, was Julian himself. Julian had a special way with people to get them to grow and open up and just have fun. That was the kind of kid he was. He was funny, outgoing, fearless, and full of life, love, and laughter. The energy he brought to the world was boundless. I even called him my copper top baby because his hair wasn't quite the same color as red as mine, but it was more of a copper color like the battery. And thank you again to the prosecution, Anna and Jillian, for fighting so hard for our boy and my wife. And thanks to the jury for getting it right. And thank you to the North Olmsted Police Department for all the work you guys did with helping on that day. And to the community for the continued support. We will be forever grateful.
My name is Margot Wood, Margot. I watched my son take his first breaths when he was born, and I watched him take his last in my arms, covered in his blood. A mother should never have to bury their child. A mother is supposed to go first, not her children. A mother shouldn't receive her child's death certificate at 3 years old, and his cause of death is by homicide. That woman murdering my son replays in my head every single day. It is my living nightmare. The last thing I will ever hear from my son is his scream, the sound of his pain and fear before he was gone. And I can still see the terror in his eyes, and it haunts me every day. He was my baby boy, and the day he died, a part of me died with him.
And so with respect to my sentencing, after taking in consideration all the matters before the court that are appropriate under the principles and purposes of sentencing, the court's going to impose the following sentence. Starting with count 2, as found guilty on count 2 of murder, it's a life with parole eligibility at 15 years. On count 3, the murder charge under the B section, it's life with parole eligibility at 15 years. And those are the maximum sentences that could be handed down on those 2 counts. On count 4, with respect to the Reagan-Toke sentencing guidelines, count 4 and count 8 are both felonies of the second-degree felonious assault. We also speak to count 5, which was the endangering children as a felony of the second degree. And then we speak to count 7 and 6. The state and I have agreed that I will move forward with count 7. Under count 7, under the Reagan-Toke sentencing guidelines on the attempted murder in count 7, the court's going to hand down the maximum sentence of 11 years as the minimum sentence to the indefinite sentence of 16 and a half years. Again, I've outlined the Reagan-Tote guidelines and the reporting requirements for post-release control that will be controlling on all other felonies of the second and first degree, this being the highest level. I've outlined the 5 provisions, as I noted for the record already. And then with respect to the count 4 and 8, the maximum sentence is 8 years. I'll hand down that sentence. Count 5, 8 years. Count 6, 11 years. Count 8, 8 years. And then as indicted, count 10, which would be a 6-month sentence on the misdemeanor charge. Regarding aggravated murder and finding the defendant guilty of aggravated murder by this jury, the court's going to hand down a sentence of life without parole. I'll run every other sentence concurrent to life without parole. Ms. Ellis, you'll be given credit to 509 days of the time that you've served. I'll order you in the custody of the sheriff to transport you to Marysville Correctional Facility. I'll also indicate that fines, fees, and court costs will be waived with respect to this sentence. In addition to the verdict that has been handed down by this jury and the sentence that the court handed down, Ms. Ellis, you have a right to appeal both the sentence and the conviction in this case. You can do that by filing a notice of appeal with the clerk of courts within 30 days of this sentence.
Here is what Ellis's lawyer had to say after sentencing.
We have tremendous respect for the process, the jurors' verdicts, that family in there, what they've gone through. No one wins in this situation. But I meant it when we said that we respectfully disagree with that verdict. And, you know, you have to understand that because demonstrated mental illness all the way up until that day, somehow just on that day, she's not mentally ill. And then following, we had to have her restored. We couldn't even communicate with this woman. So just one day out of 6 months, 8 months, she's okay. So we pushed back a little bit on that. And the difficulty with this kind of case is that jurors don't have the opportunity to understand that not guilty by reason of insanity, it doesn't mean that a person walks back out into the street or into the parking lot like what they think. We're not allowed to discuss that during the course of a trial. So that is certainly a disadvantage, and we just hope that the law changes as it relates to that aspect of it, because this kind of case is so unique that jurors should know that hospitalization could last as long as a prison sentence could last. And until they know that, it's going to be difficult because no one's going to let anyone walk back out into the street after having taken the life of a 3-year-older. So that's what I say. And, you know, again, we respect the process, and she has a right to appeal it.
And you are appealing, correct?
Yeah, the public defender has been appointed. So
yeah, I mean, I know that somebody else will be handling that, but, and it sounds maybe obvious to some of us, but on what grounds would the appeal be?
Well, I mean, the appellate lawyer would have to look at the weight of the evidence.
Manifest weight and sufficiency of the aggravated murder. She didn't plan that murder. So when you talk about prior calculation and design, there was no prior calculation for her to go into that grocery store. But for a few things happening, Ms. Woods would not even have been there. So I think manifest weight and sufficiency, and the public defender does a great job at doing appeals. So they'll look for whatever avenue they can appeal.
And just to be clear, is she appealing her conviction and sentence, or both?
Both. Both. And the other thing that I'll say about this is that, I mean, as you stand here, you all followed the trial. What is the rational motive in this case as to why she took that child's life? And if the answer is because she was angry about money not coming back from the police, then again, we push back a little bit with respect to that. So
She didn't say much. What did she say to you before you came out there or after at the end here? I mean, I guess the question I'm really trying to ask is, why didn't we hear more from her?
Well, I can't tell you what she and I discussed, or what she discussed with Mr. Johnson and I, but we know that she's remorseful, and we know that she feels horrible about this event, and that's probably where I should leave it.
Let us know your thoughts about the sentencing and how you feel about the mental health claim. From us, deep condolences to the Wood family.